Next call, State versus Cody Polatis. Please come on the council table to your turn. All right, this is KCR 33-21-1298. The time scheduled for sentencing. Ms. Cole represents the state. Mr. Grant represents the defendant who's here in person. Ms. Cole, is the state ready to proceed with sentencing today?
We are, Your Honor.
All right, Mr. Grant, is the defense ready to proceed?
Yes, Your Honor.
Very well. In this case, Mr. Polatis, at the time of your arraignment on August 2nd, 2021, you were informed that information had been filed against you charging you with a count of felony indecent exposure. That's a crime under Idaho Code 184116. At the time of your arraignment, you pled not guilty. However, on January 10th of 2022, you appeared in court again with your attorney, and pursuant to a plea agreement, you withdrew your previous not guilty plea and entered a plea of guilty to the offenses charged in the state's information. And as part of your entry of a plea, there were sentencing recommendations contained in the plea agreement that was filed. That plea agreement was filed with the court on January 7th and stated that as part of the terms of the plea agreement, you would plead guilty to that offense, which you did do. You'd be required to register as a sex offender pursuant to Idaho Code 188304A, which I confirmed is a registrable offense that you pled guilty to, and that you were to obtain a psychosexual evaluation prior to sentencing that the court could consider and the parties would consider as well for sentencing. In exchange for your guilty plea, the state agreed that it would limit its sentencing recommendation to a rider or a retained jurisdiction, and that the defense would be allowed to argue for whatever sentence you thought was appropriate, including the sentence of probation. That was a non-binding plea agreement leaving the discretion of the court to determine the sentence. After the plea agreement was filed and you entered your plea then, Mr. Polatis, there was a pre-sentence investigation report that was prepared. That was done recently on March 28th. Prior to that, also, a psychosexual evaluation was completed and filed in this case. Those documents are both kept sealed and confidential. In addition to that, there was also a mental health examination report that was filed. So I would note, in addition, I received just today some additional victim statements which were filed in the case, and I wanted to confirm with Mr. Grant, since I just received those. Did you in fact receive copies of those victim impact statements?
I received those a few minutes ago, yes.
Okay, have you had adequate time to review those and discuss those?
I've had a chance to review them. Mr. Polatis had a chance to review them, so when they go, I don't know that he has any questions about them.
Okay, thank you, Mr. Grant. This time then, I'll ask the state first if you intend to call any witnesses at this hearing, or if there are victim impact statements other than what was included in those letters submitted today.
Your Honor, I don't intend to call any witnesses. One of the parents would like to make some additional comments as a victim impact statement.
All right. Does the defense intend to call any witnesses to testify at this hearing today, Mr. Grant?
No, Your Honor.
Very well. I will proceed then, as first I'd like to have the state make its recommendations. In making your recommendations, you're free to call your victim if you do have someone who wants to present a statement to the court today. After the state's made its recommendations, then I would ask Mr. Grant to make your recommendations on behalf of your client. And then finally, Mr. Polatis, if there's anything you would like to say directly to me before I impose sentence, you can do that after your attorney has addressed the court. So Ms. Cole, you can proceed with the state's recommendations, and if you have someone that wishes to make a statement, they can do so at this time.
Thank you, Your Honor. you, Your Honor. In this case, the state's recommendation is going to be for a sentence of 2 years determinate and 4 years indeterminate for a total sentence of 6 years, with the court retaining jurisdiction and sending Mr. Polatis on the writer program. This agreement was reached in mediation, Your Honor, between the state, Mr. Polatis, his attorney, and Judge Pickett. The state believes that probation is absolutely not appropriate for Mr. Polatis at this time for several reasons. I do acknowledge that he has a significant amount of credit for time served. He has been in jail since this incident happened. However, we do not believe that that significant amount of time warrants probation in this case for several reasons, including the defendant's prior failures on probation, the fact that he has had opportunities for treatment and not taken advantage of them, and that he is in desperate need of sex offender treatment. He has also served lengthy amounts of time in jail before, while he's been on probation, after probation violations, after new charges, and sitting in jail for a lengthy amount of times has not deterred him from continuing to commit crimes. This case, Your Honor, is about 3 little girls. Those little girls have names, they have families, they were innocent children who were playing outside thinking that they were safe until Mr. Polatis sought them out. He watched them, he waited until the adult that was there with them briefly walked to her car to put some belongings away, and then he pounced on them. And when the adult wasn't there, he walked up to these children, he exposed himself, he then told them something about, would you like to see my frog, would you like to play with my frog, and is trying to trick them to, honestly, I don't know that anyone knows what he was going to do other than Mr. Polatis himself. But he walks up to these 3 little girls who are 7, 8 years old, exposes himself, and is saying things to them to trick them. As all of the parents mentioned in their victim impact statements, they've had a lot of time to think about what if Mr. Polatis had done something else? What if those girls at 7 years old weren't brave enough to walk away and know that they were in a bad situation? What if one of their parents hadn't been right there? How much more horrific could the situation have been? Luckily, they did have an adult there. Luckily, they were brave enough to say, this is not okay, and to walk away and to tell a parent what happened. When Mr. Polatis was confronted by that parent, he denied that anything had happened, and he left. He was then confronted by law enforcement and denied that anything happened. He has only since been incarcerated, admitted what he did. In the PSI, he indicates, I exposed myself with the intention of someone else seeing it. In this case, he intentionally shows 3 innocent little children. I just want to read a few things from the victim impact statements that stood out to the state. The first one from Shelley talks about how Mr. Polatis took a feeling of safety away from herself and the 3 girls that were there. She says, I'm sad that I can't think about the Warm Slough area without feeling sick to my stomach. She talks about how she saw Mr. Polatis, that he was watching them, that he was waiting, that he had a plan, and he waited until she left the area. She talks about how her daughter asks if strangers are bad guys, like the guy at the Warm Slough, that she's scared of not being right by her side when they go out in public, and that she has a stuffed animal that she likes to take everywhere with her. The statement from Mr. Ponte, he talks a lot about how Mr. Polatis does have a history, and how he is grateful that this wasn't more egregious than it was, but how Mr. Polatis is obviously engaging in riskier behavior to go from what he started out doing, which I'll talk about, to now feeling comfortable enough to expose himself in front of children. He talks about how there's a pattern and it's gotten worse, and the state would agree with that. The other parent talks about how when her daughter first recounted what happened, she was disgusted at the fact that someone would expose themselves to a 7-year-old child. She was enraged that he was trying to trick them by saying, come look at my frog, come touch my frog. He was asking them to get closer to them. When Mr. Polatis walked up to these girls, he was within just a few feet of them. He wasn't 10, 15, 20 feet away from them. He wasn't across the parking lot. He was very, very close to them. She talks about how she's grateful every single day that those girls were brave enough to turn away and run away and go find a parent. She says that this indecent exposure is not a victimless crime, which that's exactly what it is not. It is not a victimless crime. There's 3 little girls, like I said, who have names, and they have been affected by this, and their families have been affected by this. She talks about how her daughter talks about, are we safe? Can I talk to that person? This incident has impacted these little girls and will continue to impact them and their families. Mr. Polatis has a substantial criminal history. While this is his first felony conviction, he does have a lengthy, disturbing misdemeanor history, and I know the criminal history is outlined in the PSI, but I think it's important for the state to have some more information about the underlying facts of those cases. His criminal history starts in 2014 with a trespassing. He then, in 2015, has an unlawful entry that was amended from a burglary and a stalking in the 2nd degree. The facts in that case were that he broke into the home of at least 3 different girls on at least 5 different occasions before being caught. And he entered those homes to steal underwear, to use underwear to masturbate to. In that case alone, he had 5 probation violations filed. On one probation violation, he served 72 days. On another, he served 10. His probation was then extended. He then served an additional 360 days of jail with work release. In 2016, he has another conviction for unlawful entry for essentially the same thing, breaking into a neighbor's home to steal underwear. In that case, he again had a probation violation. He had his probation revoked and a term of 180 days in jail imposed. In 2016 is his first conviction for indecent exposure, where he was masturbating in the parking lot of a local business using their Wi-Fi to watch porn and masturbate. In 2018, he has another unlawful entry, again breaking into the home of a family that he knew from church, again for the purpose of taking underwear, using underwear to masturbate or do other things with. Again, he had a probation violation in that case. And then in 2019, he has a petty theft conviction for stealing a vibrator from a local store. In that case, he was ultimately unsatisfactorily discharged from probation. Your Honor, in all of these cases, he's been given the opportunity to do some treatment. He has never successfully completed any type of treatment, despite the efforts of probation over and over and over again. He was ordered to complete a psychosexual evaluation back in 2016. He never actually did. It wasn't until after the 2018 conviction that he completed the psychosexual, which in some way mirrors the psychosexual he did in this case. It's very similar, Your Honor. However, he still has never engaged in treatment, even though he's been given opportunity after opportunity. A few of the concerns that the state has in the PSI and why we think that probation is not appropriate in this case, Your Honor. His LSI score is a 22, which places him in the moderate range. He has several diagnoses related to his sexual deviant behavior, including exhibitionistic disorder and fetishism, which I think underlie all of the crimes that he's committed, including in this case, Your Honor. I think very telling by his criminal history, as well as the underlying facts of those cases, is that his behavior is continuing, but is also increasing in intensity. He has moved from trespassing to breaking into people's homes, to then exposing himself in a parking lot, to then intentionally exposing himself, and in this case, even more disturbing, picking 3 little girls. His risk to reoffend is high. which is very concerning to the state. And I wanted to read a few things from his psychosexual evaluation in regards to his risk. Dr. Hatzenbuehler, who has done both of his psychosexual evaluations, indicates that he is a well above average risk of reoffending. She indicates on page 2 that research demonstrates that convictions from non-contact sex offenses, like we have in Mr. Polatis' case, have been consistently related to increased sexual recidivism risk. Offenders with interests like Mr. Polatis are at an increased risk for reoffending, and that his offending record is consistent with the conclusions of that research. She also indicates that even following intense treatment over a number of years, significant reduction in risk is attainable, but residual risk is likely to remain. On the next page, she indicates that individuals who fall on that well above average risk, as Mr. Polatis does, are considered to be high priorities to be in need of treatment. She indicates that his risk of reoffending has increased over time as more information about his past offending has become available to her. He demonstrates clear atypical sexual interests that have expanded over time, and he now meets the criteria for both of those diagnoses that I mentioned. His risk of acting out exposing fantasies is high, and he also remains a risk for acting out his fetish interest in female underwear. Concerning to the state is in paragraph 3, where she indicates during her initial evaluation of Mr. Polatis, he was reluctant to acknowledge that he has a problem with atypical sexual impulses. If he's reluctant to even realize he has a problem, how is he going to do in treatment? Is he going to respond? Is he going to want to participate? Is it going to be successful? She indicates he is only now beginning to recognize the need for treatment. As I mentioned, Your Honor, he has been given multiple opportunities to get treatment in the community, to be supervised in the community, and he has shown this court that he cannot be supervised in the community, that he does not want to take advantage of the treatment for whatever reason, and that he can't be supervised without violating probation. He says in the PSI, I want 0 more victims. I will take full advantage of the treatment I get and follow the rules so I can be successful on probation. His criminal history the last 8 years, I think, shows otherwise. He remains a threat to the community, as Dr. Hatzenbuehler has concluded. The sentencing criteria that this court considers, the goals of sentencing including primarily the consideration of protection of society, followed by the possibility of risk reduction through rehabilitation, deterrence of the individual and the public generally, and punishment for retribution and wrongdoing, screams for something more than probation in this case, Your Honor. Mr. Polatis needs to be incarcerated longer. He needs to be able to, I guess, kind of be forced to either accept treatment or not accept treatment. Until he is forced to participate in treatment, the state doesn't know whether he can be successful on probation. I don't know whether I can recommend probation at a rider review because I don't know how he's going to do in treatment. And I don't know what his risk is going to be. And so the state believes that based on all of the factors that the court considers, based on Mr. Polatis' criminal history, based on the facts of this specific case, that the court should retain jurisdiction. We can see how he does on the rider program and determine whether appropriate probation is appropriate at that time, Your Honor. Thank you.
All right, thank you, Ms. Cole. Mr. Grant, what are the recommendations for the
Good morning, Your Honor. Ultimately, we are recommending that the court consider fashioning a sentence that it deems appropriate, but then suspending that sentence and placing Mr. Polatis on probation. And I think there are a number of reasons for that. Very clearly, the state has made a good argument. It is an argument based upon appearances. It's an argument, I think, based upon emotion. I think it's an argument based upon feelings in the community. And I can appreciate what the state has recommended there. The state made reference to the victim impact statements. I was only provided with those this morning. There is information, or there are allegations made in those impact statements, which I think the objective data in the pre-sentence investigation report and the psychosexual evaluation dispute, and which I think may be somewhat inaccurate, recognize that they were made in good faith, but certainly this did not give me time to look into some of those allegations to be able to present information to the court to dispute that. And that is a difficulty to deal with. I ask the court to take that into consideration as it looks at those statements. I guess the first thing that I will say to the court, I graduated from law school almost 25 years ago to the day. I think I'm about a week away from my 25th anniversary from graduating from law school. I will indicate that in those 25 years, almost all of that time has been spent either as a prosecuting attorney or as a defense attorney in one role or another. There have been a few years where I've done some other things. The majority of it's been involved in some capacity in criminal law. It's the first time I have ever dealt with this charge, Your Honor. I have dealt with, I don't know how many cases of lewd conduct. I don't know how many cases of sexual battery or sexual abuse of a minor. A number of cases involving child pornography. First time ever I have dealt with a felony charge of exposing oneself. So I would assume that's probably a similar situation for the court, probably a similar situation for the prosecuting attorney. If I could ask that the flash not be used.
I
don't mind the camera.
Sure.
Sorry.
That is something I don't think any of us have dealt with much. This is typically dealt with as a misdemeanor. And quite honestly, what we deal with in district court typically are much more significant and serious crimes that usually involve sexual violence, sexual touching. They involve a great deal of coercion. They involve a great deal of manipulation. And they involve individuals who are using sex to obtain power and control over other people. Whether those be rape cases, I didn't mention those. I can't count how many rape cases I've been a part of. Several forcible rapes, and I don't know how many statutory rape cases. And this is just a very different situation. And I will come back to that in a minute with some of my recommendations, but I think it's fair to say that none of us really know exactly the standards in dealing with this type of a charge in district court. We're probably all treading some new territory. The state recommends a retained jurisdiction, a rider. If the court sends Cody on a rider, I've been doing this long enough to know that the Department of Corrections will send him to REU, and they'll take a quick look at the pre-sentence investigation report. They'll take a quick look at the psychosexual evaluation, but it will already have been likely a determination made that he's going to be put into a sex offender treatment program following that rider. And there are some benefits to that, no doubt about it. There are some treatment opportunities there. Ms. Cole alluded to that. But what we will do by putting Cody into that population is that for 6 to 9 months, he's going to be with rapists. He's going to be with those who have physically molested children. He's going to be with those who have inappropriate sexual relationships with teenagers. He's going to be with individuals who are very manipulative, very controlling, who want power and control, and violent individuals. I've never seen anybody go on a rider, again, for exhibitionism. But I've seen a lot of people, for some of those crimes I just mentioned, do riders or retain jurisdictions. And then Cody's going to be put into a classroom with these individuals, 25, 30 people, and they're going to do a workbook. That is the majority of their treatment program. And they're going to do some once-a-week group counseling, where they'll be in maybe smaller groups, 10, 12 people. There will be very little individual counseling, maybe 1 or 2 meetings with a counselor, maybe 1 or 2 meetings to put together an aftercare plan, and to put together an addendum to the pre-sentence investigation report. But very little individual customized counseling for Cody, for a very individual, unusual charge. And in addition, while he's doing that rider program. There will be very little done to address some of his mental health issues. The documentation is very clear that Cody deals with a depressive disorder, that there are some mental health indications and concerns that go beyond the mental health association or associated determinations of a sexual nature. Those are not going to be addressed on a rider. And Cody suffered a head injury as a child, and they're not going to take into consideration the group counseling and the classroom working through the workbook that traumatic brain injury. That has affected Cody his entire life and affected him through his education process. Yet treatment in the community, I think, can deal with those situations a little bit better. Essentially what we do by sending Cody on a rider, Judge, is we put him into a situation where he interacts with and spends 6 to 9 months living with individuals that he is not. And he spends that 6 to 9 months getting treatment to try and stop him from being one of those individuals that he is not. And then we have the concern in the community about the influence those individuals have had on him in a group setting. And that concerns me. I think to send him on a rider in the short term, I guess that addresses some concerns in the community. I think it addresses what our community feels is important regarding retribution and those types of things. But I think it's short-sighted. I think in the long term, we are better off placing Cody in the community. And I'll come back to that in just a minute. I think in the community, we can set Cody up with some treatment and some help that is focused on preventing him from becoming one of those individuals who he would be with on the rider program. And I think that that is perhaps a little more long-term focused, perhaps has a focus further down the road in ultimately being able to protect the community and being able to help Cody and rehabilitate Cody. I focused in part with my comments on a lot of the objective information in the pre-sentence investigation report and the psychosexual evaluation. Not so much on my feelings as to what we're doing with an individual, on what Cody's feelings are, on what the state's feelings are, but on the data from the experts, the pre-sentence investigator, Dr. Hadson, who did the psychosexual evaluation. And I think that data backs up a recommendation of treatment in the community. I will indicate, Your Honor, on pages 4 and 10 of the pre-sentence investigation report, it indicates that Cody has been fantasizing about and has an increased interest in frottage. I think that that's one of those, perhaps that was a little bit of a misunderstanding with the polygraph on the psychosexual evaluation. Cody had mentioned, I think in meeting with Dr. Hatzenbeber, that he had thought about at times engaging in behavior that would be considered frottage. He didn't even know the meaning of the word. He hadn't heard of the word. He hadn't seen anything online involved with it. It was something that he thought of. And so it got included as being some kind of fantasy thing or increased thoughts of it. And he was just admitting it was something he thought of in the past. In fact, the individual who did the polygraph had to tell him what the word meant. And so we do dispute those comments on pages 4 and 10 of the PSI. We think that they're inaccurate, but I don't know that they changed the recommendation a whole lot. But I wanted to bring that up. I want to indicate first from the data that this was not an incident that occurred because Cody was focused on children. It was an incident that occurred because Cody was feeling impulsive and wanted to do something, and it happened to be the kids were there. Now that statement I want to make clear does not downplay the nature of what happened here, and I'm not trying to do that. But the data, the psychosexual evaluation, the pre-sentence investigation reports indicate that Cody has no history of sexual interest in children, has no background of any behavior involving children, and it does not appear that he fantasizes about or includes children in any way in any of his sexual activity or sexual thoughts sexual behavior. I think that was very clear from Dr. Hatzenbuehler as well as in the pre-sentence investigation report. Again, I don't want to downplay the seriousness of what happened to 3 young girls, but he was not focusing on children specifically. It was impulsive conduct. It happened to be that the kids were there and were available, and perhaps that was an opportunity because they were kids. Now, that comes to some data that Dr. Hatzenbuehler talked about. And one of the evaluations that she did, I remember it was the Stable 2007 or the Static 99, one of the areas that they evaluate is psychological coercion. This was a new concept to Cody, a new idea to think about for Cody. And Dr. Hatzenbuehler and Cody discussed what that meant and what that was. And Dr. Hatzenbuehler indicated that by singling out kids, that was a form of coercion, in part because they're not adults, they might react the way adults would, and those types of things. And that has been an eye-opener for Cody. That's something that he has not given thought to. That is the kind of behavior, that is the kind of conduct that individuals who are completing riders for sex offenses engage in and think about. It was new to Cody. He wants to stop that. He does not want to engage in psychologically coercive behavior. And so doing this psychosexual evaluation was an eye-opener for him in some ways and gave him some additional insight into his conduct and what he does not want to become, he does not want to do. He does not want to become an individual who engages in lewd conduct with children, who abuses teenagers, who has inappropriate sexual relationships with teenagers. That is not something that he wants to become. And so I found that to be enlightening, and that was a good part of the conversation that I had with Cody. Dr. Hatzenbuehler indicates some other things as well. She indicates that the psychosexual evaluation she did a couple of years ago and the new psychosexual evaluation largely have come up with the same conclusions. And her conclusions basically are no different than these two. But she did point out a big difference between the two. And that is in the first one, Cody was unwilling to acknowledge a need for treatment, was unwilling to acknowledge inappropriate behavior, or that behavior was based upon what we would consider to be unacceptable or inappropriate social constructs. She's indicated that Cody is now beginning to realize the need for treatment. And several times throughout her evaluation, and it's mentioned in the pre-sentence investigation report as well, that Cody is open to treatment, recognizes a need for treatment, and wants to make sure that this doesn't happen again. In fact, Cody mentioned in his own statement that he wants to make sure this doesn't happen again. That he recognizes that he created a negative situation in the community and harmed some individuals, and he does not want to do that in the future. That is a big difference, I think, between the early psychosexual evaluation and the new psychosexual evaluation. Dr. Hatzenbuehler concludes that yes, Cody's a high risk to reoffend. She concluded that before. But then she also concludes that appropriate treatment that is community-based should be able to address that and be able to meet those needs and reduce Cody's risk of recidivism in the community. Now, she concluded that before as well. And the state very aptly points out that Cody, on previous probations, has had some struggles, no doubt about it. I think that we're in a very different position now for community supervision than we were a couple of years ago with Cody. First and foremost being that Cody recognizes a need for treatment and a desire to put this behavior and this thought process behind him. That was not in place when he was on probation before. A second factor is that he will be on felony probation. Much more significant level of supervision. They're going to do regular polygraphs. They're going to make sure that he is attending his treatment with a qualified treatment provider in the community. And they're going to make sure that he doesn't have internet access as suggested by Dr. Hatzenbuehler and those types of things. Now, I don't want to downplay Cody's responsibility in those probation violations brought up by the state, misdemeanors, but the data, again, indicates that some of those failings perhaps were not Cody's fault. He wasn't given regular polygraphs. No polygraphs at all on his probation. He was ordered to get a psychosexual evaluation, yet that wasn't required to be completed by probation for quite some period of time. In addition, he had access, he had a cell phone where he could get cellular data. No search was ever done to see if he had that. He was never, no inquiry was made as to whether or not he had the cell phone and those types of things. So I think that with felony supervision, those are not going to be issues. Dr. Hatzenbuehler suggests no internet access, regular polygraphs, regular contact with the treatment provider, those types of things, and standard terms and conditions of probation, such as a search of a residence and those types of things, I think put Cody in a very different position to succeed than when he was on probation as a misdemeanor. But again, I think the main factor there is that Cody is open to treatment and wants treatment, as documented by Dr. Hatzenbuehler. A couple of other points with Dr. Hatzenbuehler. One I mentioned before, Cody does not appear to have an interest in children. That does not appear to be a focus for him. You place him into the community. Is there a risk of some type of inappropriate behavior? Yes. Is there a risk to children? I don't think so. And then Dr. Hatzenbuehler, and it's mentioned in the pre-sentence investigation report as well, indicates that, yes, Cody remains a high risk to reoffend. But where Cody has not changed, or where Cody is a low risk, is he does not appear to be a risk for sexual violence, touching people, the manipulation, the control, those types of things. Dr. Hatzenbuehler mentions that several times. There are a couple of factors in several of those evaluations that she did that indicate that. And then in her summary, she indicates that yes, Cody's a high risk for some type of behavior in the community, but at a low risk for behavior that involves sexual violence, touching, those types of things that become particularly concerning in the community. And so I think that we have that objective data as well, Your Honor, to rely on. When I look at, well, Your Honor, I guess here is how I would suggest our recommendation would fall out. I think a sentence, 2 years fixed and 4 years indeterminate that the state recommends, I don't think is inappropriate. But where we would ask for the difference, Your Honor, is we'd ask the court to suspend that and place Cody on probation for several reasons. Cody has been in custody now for 265 days. He has done well while in custody. He's not been a discipline problem in the jail, nothing along those lines. In fact, Cody has done what he can to avoid interaction with those whose behavior is perhaps a little more overtly criminal. And he has tried to engage in some behavior and some treatment that is beneficial. Now, with COVID-19 restrictions in place the last couple of years, some of the programming in local jails has gone away. I hope that it comes back as we get things under control regarding coronavirus. But some of those things have gone away. But one thing Cody could take advantage of was a 12-step program offered by the LDS Church. It was open to anybody. And Cody has spent significant time engaging in that 12-step program. When people involved with the program were allowed to be in the jail, he went and met with them. Otherwise, he worked with things on his own. He has found some things to be very beneficial there as well. In fact, I would indicate, I think a part of his recognition as to his wrongdoing here and taking responsibility and recognizing the need to change it, in a large part has come from completing that program. So he's done some positive work there while he has been in custody. He is anxious to get into the community and do some positive things there. He would be able to reside with his parents. Now, the pre-sentence investigation report and the psychosexual evaluation indicate that Cody was residing with his parents at the time this occurred. That was kind of true. Cody was residing in a home owned by his parents here in Madison County. It was a home they were no longer living in. They had recently moved to Hammond, Idaho. And Cody was remodeling the home and repairing the home, getting it ready for sale. Since Cody's been in custody, that home has been sold. And when placed into the community, he would be in a very pro-social supportive environment with his parents initially in Ammon. He would be residing there where the majority of the qualified treatment providers for the type of treatment Dr. Hatzenmuller recommends practice is in that area. And so he would be able to attend his treatment there and then be able to be under supervision of the Department of Corrections in the area. Cody, not a long time before this incident occurred, Cody had earned his commercial driver's license. And so employment is likely not an issue. Cody can get jobs driving. He hopes to find something local so that he's not over the road and exposed to some of the challenges there. And then Cody has some skills regarding construction, home building, those types of things as well. And in fact, his hope is to be able to start buying some residences and repairing them and flipping them, those types of things. That's a goal of his. I think that's a very productive thing to think about. And so there are some very positive pro-social reasons for placing Cody into the community. I want to focus a little bit on the treatment he would get in the community, as opposed to the we're treating everybody in the same way, all at the same time approach with a rider. Cody, with treatment in the community, would be able to obtain treatment through a qualified sex offender, sex therapist, counselor. He would be able to meet with that counselor one-on-one on a regular basis and obtain the type of counseling that comes with getting to know an individual and knowing about them, and knowing their personality, and knowing their strengths and weaknesses, and getting a very appropriate form of counseling there. He'd be able to engage in group counseling as well, which is not uncommon at a certain point in that type of counseling. And he can meet with a counselor who can also address his mental health needs, the depression, medication issues, those types of things, which he's not going to get on a very close, intimate basis with the Department of Corrections. And then he can work with a counselor who is aware of the traumatic brain injury, is aware of some of the deficits that are involved with that, and be able to customize that treatment to address some of those issues so that Cody is getting effective treatment because a counselor is aware of the deficits involved with that traumatic brain injury. And so I think that is another reason to support treatment in the community. When I look at the factors the court has to consider in this case, I look at deterrence. A suspended sentence, but with a significant tail of 4 years, an indeterminate like the state recommends, I think meets that deterrence requirement, both to Cody to engage in additional conduct as well as to the community in general. Cody would know that if he messes up on probation, he's not going to go in and do 120 days or 76 days, like with a misdemeanor violation. He's got some significant time hanging over his head. He knows that he'd have a 2 to 6 year sentence hanging over his head if that's what the court were to look at. I think that meets the deterrence. Community protection, we are keeping, with placement in the community, we are keeping Cody away from those individuals who are much more inclined to violent sexual behavior. We are keeping Cody away from their influence. Cody will have to register as a sex offender in the community, and so people have access to where he is residing. That is public record, and it's something that can be looked up online in a matter of seconds. And Cody will be engaging in very meaningful and productive treatment. When I look at rehabilitation, Cody will have that one-on-one counseling that I mentioned earlier. And then, Your Honor, when I look at retribution, punishment, Cody's going to have to register as a sex offender, potentially for life. That is a significant punishment. He's been in custody for 265 days and handled that appropriately and maturely. That's a significant punishment. And then the court, with a lengthy tail end on a sentence, can look at a lengthy probation if it needs to make sure that Cody is behaving appropriately in the community. And I think that in looking at that, in looking at the data, in looking at the recommendations made by Dr. Hatzenmuller, and looking at the data that's included in this pre-sentence investigation report, Cody is, I believe, a good candidate for probation. I believe that the court can meet the factors that it has to look at in sentencing under the Two-Hill decision here in Idaho. And I think the final thing that I will mention in support of placement in the community is Cody's LSI score, 22, places him just into the moderate risk for recidivism overall. 21 is the cutoff. Had he been at 20, he'd have been at a low risk. Cody is in a position to succeed in the community. He's not a high risk to the community from a violence standpoint, from an overall recidivism standpoint, and the treatment that Cody needs to reduce his risk to the community for some type of reoffense of a sexual nature is best available in the community on a one-on-one basis, customized basis, while on supervision. And that would be our request, Your Honor.
All right, thank you, Mr. Grant. Mr. Grant, I have something over at the beginning of this, which I need to ask counsel in terms of referenced and talked about the PSI and the psychosexual report. The court did receive copies of those, as I mentioned. I needed to confirm on the record that in fact those were both received and reviewed by you and your client, Mr. Grant. Did you in fact receive those before sentencing and review those with Mr. Polatis?
Yes, Your Honor.
All right, and I should have asked much sooner, but did you have, I understand and noted where you disputed some of those findings on page 4 and 10. Did you have any other corrections or clarifications you think were required in either of those reports?
There were some conclusions made by Dr. Hatzenbuehler in the psychosexual evaluation that I don't really think require an objection, so I think we will leave it at that.
Okay, I appreciate that. Mr. Grant, I didn't ask the state either. Will the state have any proposed corrections or clarifications to those reports, Ms. Cole?
No, Your Honor.
All right, thank you. All right, Mr. Polatis, before I announce sentencing, is there anything you would like to say to the court?
Yes, Your Honor. I would like to first apologize to the families and the children that have been involved. I realize that this has been something that has affected them. And second, just with my attorney's recommendations, I'd like to realize that I do have a problem, and I noticed that, and it needs to be worked on, and I need to take advantage of whatever help I do get, because I don't want to continue this behavior. It's bothered me, the fact that what I've done to these little girls, and that's something that I get to live with for the rest of my life, no matter what. Even though there was no touching or anything like that, it still has bothered me. And with that, that's what I have to say, so thank you, Your Honor.
Okay, thank you, Mr. Polatis. All right, Mr. Polatis, are you fully satisfied with the representation you received from your attorney?
Yes, Your Honor.
All right, this time then the court has considered these recommendations based on your plea of guilty. It is the judgment of this court that you are guilty of the offense of felony indecent exposure under Idaho Code 184116 subsection 1. The court has reviewed these reports, including the psychosexual evaluation prepared by Dr. Hatzenbuehler, the pre-sentence investigation report, and also those sub-reports of the PSI, including the mental evaluation that was done. I've considered some of the important determinations in those reports, some of which have been discussed today. You're 27 years old. Your LSI score, which looks at a propensity to reoffend, came as a 22, which puts you in the moderate category. The PSI recommends a retained jurisdiction. The state does as well. Your attorney has recommended a time of probation and release from custody. I've reviewed your prior criminal history, and I've also looked at the sentencing objectives of Idaho Code 1925-21 and the State versus Tuhill case, which involved the protection of society, the deterrence of the individual and public generally, possibility of rehabilitation, and punishment or retribution for wrongdoing. As Mr. Grant pointed out, it's somewhat of an unusual offense to have a felony. It isn't the first one I've seen or dealt with, but they're not common, I'll note that. the court looks at not just what the offense is, but I have to look at the offender and the particular aspects and characteristics of the offender also, when I'm determining an appropriate sentence and considering those factors. While there are those 4 different specific sentencing objectives, I'd note that some of the case law also clarifies that the primary and most important objective is the protection of society, and that's under the State versus Tugel case, which calls that the primary objective is protection of society. When I look at the record in mitigation, this is your first felony conviction, Mr. Polatis. However, there are several previous misdemeanor convictions, and as I think correctly noted by the state, it's a concerning criminal history because I think all of it is related to these sexual behaviors which you have, which are inappropriate in society and illegal. And starting clear back in 2014, and the real concern is the history of not just the charges, but what happened after the charges, and the fact that there was a continual pattern of your failure to comply with probation, and then subsequent offenses happening with sort of an escalating and continuing course of conduct that's led you here to this felony. And that 2015 case, as pointed out, a whole bunch of probation violations. 72 days in jail did not stop your behavior from continuing. And then finally several probation violations with more jail time issued by the magistrate, and finally 360 days in jail, which is more than we've done here on this case, which still did not stop the conduct as I see it, continued to escalate through your criminal history. You received another charge. That resulted in a revoked probation, 180 days of jail. Another charge, which is part of this felony case because it was your first conviction for indecent exposure in 2016, jail time. And then in 2018, after 4 years of this going on and out of jail, unlawful entry and probation violation, and this was entering into people's homes for purposes of your sexual gratification in somebody's private place with people's private belongings. And that probation was revoked and sent down. And then the petty theft charge came after that, 2019. Probation, unsatisfactorily discharged, a whole bunch of jail time served there too. And now we arrive at the offense that occurred here, where it's extremely concerning to me, Mr. Polatis, that what you did to 3 little kids that were just out having fun in a place that should be safe. And while you didn't physically touch them, you did victimize them, and you victimized their families. And the real concern I have, Mr. Polatis, is it does seem to just be a pattern of escalation here. And deterrence is something I have to really strongly consider. When I was reviewing all that then with the criminal history, I was very interested to see what the psychosexual evaluation would reveal. And just to summarize, it's very concerning to this court. And I've seen my fair share of these. And I think in terms of the likelihood of reoffending or the risk level of reoffense, which was determined in this one, it's up there about as high as anything I've seen as a judge. And when I take all of that into consideration, I have to look at what accomplishes the sentencing objectives here. I agree that you've done a lot of time in jail here. I know you've done a good time in jail. You've been cooperative. Your attorney has really put a tremendous amount of time and work into arguing for you and made some points I've considered, which I think he's done his best to make that argument for probation, and the state's asked for a retained jurisdiction. I've looked at all of that, and again, this pattern of escalation, which is not diminished even with prior incarceration. If you had opportunities for treatment, you could have engaged in that before. You had a prior psychosexual evaluation before, you didn't do any serious treatment after that. And so here we are, and I have to determine how to best accomplish these sentencing objectives. So with all that in mind, the court is going to sentence you as follows, and the sentence is really primarily based on what I think is this primary objective, is protection of society. Because at this stage in where you are, Mr. Polatis, I think you demonstrated that you're a real threat to society and to this community. And for that reason, I'm going to sentence you to a fixed minimum term of 2.5 years, followed by an indeterminate term of 4 years for a total unified sentence of 6.5 years. I'm not going to retain jurisdiction on that, Mr. Polatis. You're going to serve that 2.5 year prison sentence. I'm going to issue a fine in the amount of $1,000 plus court costs, and you'll be required to register as a sex offender pursuant to Idaho Code 188307. Once you are given credit for time served. As we counted it, it was 262 days is the count we had. If that needs to be corrected, we'll make sure you are getting appropriate credit for all the time that was served. I don't know that there's a restitution request from the state. Is there a restitution request, Ms. Cole?
Your Honor, I don't believe so, but if I could just have 30 days to verify that, but I don't expect one to be coming, Your Honor.
All right, the state would have up to 30 days to file a request. If it's not filed within that time frame, it's considered waived. And then, Mr. Polatis, you'll be subject to the supervision of parole once you've completed that first part of the prison sentence. So that's the judgment of the court. Ms. Cole, do you have any questions or anything I need to clarify or add on that judgment?
No, Your Honor, thank you.
Thank you. Mr. Grant, anything I need to correct or clarify?
Thank you, Judge.
All right, thank you. Mr. Polatis, I will advise you of some important rights. You do have the right to appeal for my judgment within 42 days if you believe it's an error. You also have the right to seek relief from this judgment under Idaho Criminal Rule 35 within 120 days if you think the sentence is illegal or too harsh. You also may have rights under the Idaho Uniform Post-Conviction Relief Act. You have a 1 year time frame within which to file those, and your attorney can further advise you if you think any of those post-conviction rights apply to your case. I would ask the counsel to submit back to the court any copies printed of the pre-sentence investigation reports or psychosexual evaluations, so those copies can be destroyed and the information is kept confidential. Mr. Polatis then will remain to the custody of the sheriff of Madison County to be delivered to the Idaho Department of Correction for execution of the sentence. So that will conclude the sentencing, and we will take a brief recess, and then I'll call Mr. Brown's case.